Well, good afternoon, everybody. My name is Ben Rhodes. I'm the Senior Vice President with CAMS. Thank you for joining us. Today we have Valerie Giovanoli. Hopefully I said that correctly. With us today to talk about disaster planning and storm readiness. Hopefully, knock on wood, we don't have any storms this year, but being in the South, that always tends to happen. Unfortunately, I know in the lower South just yesterday, there were tornadoes that blew through. So hopefully that doesn't hit us anytime soon. But hurricane season is also underway. So unfortunately, we're doing it again. Anyway, Valerie, before we get started with you, I'll just mention to everybody, we will be taking questions throughout the session. So if you do have a question, please enter that in the Q&A feature down at the bottom of the screen. We'll be able to answer or ask those questions throughout the session. And then we'll save a little bit of time towards the end. If you have questions, I'm happy to take those as well. We do record the session, so if you have any board members that can't attend and you want to let them watch that, this session will be posted on the camsmgt.com website under board member resources. So please check that out, or check out any of our other webinar sessions that we've held over the last couple of years. So Valerie, I will stop sharing my screen and turn it over to you.
Thank you. And thank you for having me. So like Ben said, I'm Valerie Garcia Giovanoli, and I am an attorney at McCabe, Trotter and Beverly. My firm is a full service firm for community associations. We have our main office in Columbia, South Carolina, and we also have an office in Charleston, South Carolina. I am licensed in South Carolina only, well, also Florida, but I understand that we may have some folks from North Carolina. So just want to let you know that I'm not going to be talking specifically to North Carolina law. This is going to be educational and hopefully can provide some guidance that can help all of the associations and directors that are out there listening. I'm actually going to go ahead and share my screen so you guys can see my lovely PowerPoint that I have prepared. And we're going to play. So the first thing that I would start with,
Valerie, if you want to switch to the display. So
yes, thank you for pointing that out. There you go. All right, so the first thing that I like to talk about whenever we get into discussing natural disaster and storm readiness is, where do you look to figure out what you need to do and what specific requirements govern your particular association? And where you would start is going to be your governing documents. And we know what governing documents are, I assume, but if you don't, these are going to be your declaration of covenants, CCRs, restrictive covenants, whatever they are called. They are going to be your main document. If you're a condominium, you're most likely going to have what's called a master deed. And then you're also going to have bylaws. You may have rules and regulations, and you may also have architectural guidelines and the like. There are various other documents, but the main document that you're going to start with is going to be that declaration or that master deed. That document, hopefully, is going to lay out provisions that address insurance, deductibles, what's required to be insured. It's going to address the responsibility of the homeowners association. It should also address the responsibilities of the individual owners in the association. It oftentimes will address reserves, assessments, and if you have any caps on raising assessments or where the assessments can be set. And all of these are relevant provisions that are going to play into your storm readiness plan. So one of the things that I do want to say, though, is that a lot of these documents, all of the documents are drafted by attorneys. They are legal instruments, and oftentimes you'll find that they are not as clear and easy to read or even interpret. And so I do strongly recommend that you consult with your association's attorney to help you interpret those documents and apply them to your particular community and the plan that you're creating for natural disasters and storm readiness. So going into those governing documents, like I mentioned, some of the common provisions that we see are what to insure. That's going to vary from document to document, so I'm not going to speak to any specifics. I'm going to kind of parlay right now into the statutory law in South Carolina, which is the South Carolina Horizontal Property Act, and this governs just condominiums. Horizontal property regimes is what they're called. North Carolina has a similar act. I am not familiar with it because, like I said, I'm not licensed there, but there is one. So all of you directors out there, you should be somewhat familiar with that, and you should be consulting with your association attorney so that you're ensuring that you're complying with that North Carolina statute. So what to ensure? We got typically in a condo regime, you've got common elements, limited common elements, and then your units, or otherwise called apartments. In South Carolina, we have a specific statute that says that the property has to be insured by the association. I have the word property underlined in that statute that I've cited verbatim, and you'll notice that it is not capitalized. However, in that act, they actually define property with a capital P as basically all of the land that is part of the horizontal property regime. That could be your parking lot, your building, all of the structure of the building, the individual units, the air spaces within the condo units, all of the property is property. And so I've heard arguments be raised that we don't have to insure even units. We don't have to insure everything because the statute says property with a little p. It doesn't mean property with a big P. I take the position and the abundance of caution that the association should be insuring the entirety of their property. And that is so that if there is some catastrophic event, you have the ability to use those insurance proceeds to rebuild everything. When you get into, well, what exactly inside of the unit has to be insured or rebuilt by the association, you get really into the weeds. Can't provide any specific advice on that. If your governing documents are more specific, you certainly want to look at those. But if not, it's typically going to be undecorated surfaces out, so that an owner can go in and put the paint they want on the walls and put the carpet they want in and the appliances and the countertops. That is typically going to be something an owner is going to insure through their HO6 policy. But I did want to bring that to everyone's attention that in South Carolina, we do have a statute, and my opinion is that it does require a condo regime to insure the entire property.
Hey, Valerie, I'll just mention a couple of things with North Carolina. The North Carolina statute is 47C. We have held a webinar specifically on condominium insurance. So it was about a year and a half ago we did that. So if you do have questions regarding specifics on condominiums and say insurance claims in condominiums, there is another webinar. Within condominium statute in North Carolina, it talks about the units, and the units are included, and it does speak to betterments and improvements. So there's some specific language in our statute that does address that as well.
Well, I would appreciate it if our legislator would take a look at North Carolina's law and consider revisiting ours. But what we have is what we have. I appreciate that addition, Ben. Just continuing along on other provisions that are common in association governing documents would also address how much insurance. Sometimes there's not specificity, and a pretty general rule is that you want to insure the full replacement value. So in worst case, this, you've got a catastrophic event and you've got to rebuild, you want to ensure that there's adequate funds to do so. Another thing that may be addressed in the governing documents are deductibles, and I'll get to my next slide actually addresses a very common question that we get a lot: who pays the deductibles? But for purposes of this part of the presentation, that may be something that is addressed specifically in your governing documents. There's also typically some provisions for owner insurance. A lot of governing documents require that owners purchase insurance on their own unit. And even if it's in a single family, detached residential community, you see oftentimes that insurance over the improvements is required. And the thought there is that if somebody has their house burns down, you want them to be able to rebuild, have the funds to rebuild, and you don't want to have to sit there and look at a half-burnt house or an empty lot, and that could potentially impact the rest of the property values in the neighborhood. So owner insurance provisions are very common. And then also repair and reconstruction. A lot of times these documents will tell you if there's a vote needed to rebuild or not to rebuild. And then typically a process for it. Is there going to be a trustee appointment that's going to manage the insurance funds and dictate where they're going to go for the purposes of rebuilding? So those are some common provisions you'll see in those governing documents. Like I mentioned earlier, deductibles. That's a very common question we get. Who pays the deductibles? You get some event that happens and maybe not all the property is impacted, maybe just a certain amount of units. Let's say you've got 50 units and only 3 units were impacted by some storm event. There isn't any law on this other than our statute, which is a little bit, it conflicts. There's certain provisions that conflict, but there was a recent Attorney General opinion in 2017. I've just kind of screenshotted a little so you can see some of the information from that opinion. The Attorney General actually has a website where you can go through their archives of opinions and search them. You can use a keyword search. The easiest way to find this one is by the date. They actually order them by date. So I really think it's a great read. If not for you individual directors, at least for your attorney, that to make sure that they're aware of it. But so the Attorney General opinion is just that. It's an opinion. It's just like if you get an opinion from any attorney, it's not binding on any court. You know, a South Carolina court is not going to say, well, what the Attorney General says is the law. But it is persuasive. And so I do like to make sure my board members know that this opinion's out there. And essentially what it says, it's pretty long, but what it says is that there are 2 provisions specifically, and I've quoted them here, 2731-250 and 2731-260. This is the Horizontal Property Act, so we're talking about condos. And one says the cost of repair, replacement in excess of insurance proceeds and reserve must be considered a common expense. So that it seems pretty straightforward. All the costs in excess of the insurance or what you have in reserves is a common expense, and common expense is defined as an expense shared by all of the common co-owners. 260, however, actually says where the property is not insured or where the insurance indemnity is insufficient to cover the cost of reconstruction, the rebuilding cost shall be paid by all the co-owners directly affected by the damage in proportion to the value of their respective apartments. So that you can see the overlapping portion of that provision is where the insurance indemnity is insufficient to cover. Well, doesn't 250 say the same thing, but says everybody shares in it? And so ultimately what the Attorney General said was that because 250, section 250, the one on top, was amended more recently, it's going to trump that portion of 260 that is older and in conflict. And so what they ultimately said was if it's insured, but you don't have adequate insurance or, you know, the deductible, there's cost on in excess of the insurance proceeds, that's going to be a common expense. But if you don't have insurance altogether, then it's only going to be shared amongst the units that are impacted by the damage. So that's how they kind of reasoned with that. I don't disagree with that opinion, but that's kind of where we are. The courts haven't ruled on it. An issue hasn't gone before the court in order for us to have some case law to help us fully understand what the actual law is or will be on that. And so this is just kind of another way of putting it, what the AG opinion found. Deductibles are or where insurance is insufficient is a common expense. And when the property is not insured, the co-owners that are directly affected by the damage share in the expense. And that's regardless of how many units are impacted. So, you know, you have one unit that's impacted from a catastrophic event and you use the insurance to pay that and it's insufficient, or there's a, you know, $5,000 deductible, everyone's going to share. Even though 99 of the other 100 units are not going to actually receive any benefit. But likewise, if it happens to their unit, they get the same benefit. So no questions on that. I'll move along to next topic. and that is repair and reconstruction. So I just always want to emphasize that check your governing documents. That's certainly somewhere you're going to want to look for specific governance on how your association must handle it. But generally, for condos, we've got statutes that directly address this. And essentially 250 in that recent amendment says the property has to be repaired unless it's illegal or 80%, including the affected owners, vote not to repair. And that's important, that provision that says including the affected owners, because if only 10% of the units are impacted, and 80% are say, we don't want to pay to repair those units over there. Maybe it's sort of a townhome. Maybe it's not necessary to the overall development, like the bottom floors of a high rise. They can't vote without those affected owners voting as well. So it's got to be 80%, including the owners that are affected, have to vote not to repair. 2731-250, if the property is not repaired, it goes into how the insurance proceeds would be used. So you get this big pot of money. Maybe the association, I've had this happen in the past with a burnt down condo and at the beach. They didn't want to repair. It was a vacation home for everyone and no one wanted to repair. They just would have preferred to take the insurance proceeds and then sell the property after they cleared off the building, the remainder of the building that was left. But 2731-250 helps us understand how those insurance proceeds are going to be used if you don't rebuild. And so the proceeds that are attributable to the common elements, and when you say that, you're thinking, you know, parking lots, building, green spaces, any of the shared areas. It's going to go to restoring those damaged areas to the condition compatible with the remainder of the property. So what I mean by that is if you've got a condominium regime that's got 4 separate buildings and only one is damaged, maybe you vote not to rebuild that one building, but you do need to use those insurance proceeds to demolish the debris that's left over. Make sure the area is cleaned up. Maybe you need to plant some grass or some vegetation. Maybe you want to pave it, make a parking lot, but it needs to be restored at least to be compatible with the rest of the property. Any proceeds that are attributable to limited common elements, and I see Ben popping up. We got a good question.
Well, I do have a question. I can let you finish your thought, but
okay. So the limited common elements, those are essentially common elements that are only for the exclusive use of certain unit owners. Best example I can usually give are balconies in a condominium. But if those proceeds that are attributable to the common elements or the units, which those are individually owned, those are distributed to those owners or the lien holders. If there's a mortgage on one, they're going to get the money first before the owner gets it. Any surplus funds would go to the owners. And then any of the remainder funds are actually going to be distributed to all co-owners or the lien holders in proportion to their percentage interest. Last point on this one is just the duty of care is always applicable in any of these circumstances. If you are going to rebuild and you're going to hire contractors, general contractor, engineers, any of your vendors, you need to be vetting them. Don't just take the first, a storm comes through, you get these storm chasers that come through and they're quick and you think, well, everybody else we've got a wait to get in with all these other local contractors. Be sure that you're vetting your contractors. You want to make sure that you get multiple bids to ensure that you're getting a fair price. And you want to make sure that those contractors are licensed and insured. And do a little deep diving. Go on, the internet, see if there's any bad reviews. You can look to see if they've got any judgments against them. I can't tell you how many times I've had clients come and say, man, this guy took all of our money and didn't do anything. And I pull them up and do a quick search on the court's website and say, yeah, the guy's been sued 16 times for the same thing. So vet your contractors. That's part of your due diligence. So Ben, what's your question?
Okay, the question has to deal with insurance proceeds. And when let's say it's a 30-unit condominium and 20 of the 30 units are damaged, should the association disseminate that money out to the individual unit owners to handle their own reconstruction inside their unit, or should the association be responsible for facilitating those repairs?
So I definitely say the association, and there's multiple reasons for that, but I'll always qualify my statements with look at your governing documents. So sometimes they're very, very detailed in how to handle that specific situation. But because in a condominium, you've got the common elements in the building structure itself, you want the association to have oversight over that to ensure uniformity. It's almost impossible to have, here's your money, now you fix those walls and that structure and that plumbing. You want the common elements to all be managed and rebuilt by the association. Now, with regard to the units, again, I go back to, I think at a minimum, it's the undecorated surfaces out so that they have a blank slate to go in. Some documents actually will say that the original installations and fixtures are on the association would have to rebuild those. We run into a lot of problems with provisions like that with condos in the 80s because half the board that's there now are like, we don't know what was originally here. This person has marble, this person has carpet, and so you get into this. How do we handle what we're going to replace in each unit that's fair to everyone when we don't even know what the original installations were? So those problems do come up, but typically you're going to have the association managing those funds and decorating undecorated surfaces out, and then apportioning, if you don't have to do any of the interiors, if there is money proceeds for the units and the interiors, you could distribute those across the owners pursuant to their percentage interest.
Well, very good. I've got a bad story about an owner not vetting a vendor properly with an insurance claim. If I'll tell it real quick, but
yeah,
they distributed the money out to the individual owners. One of the units was not properly vetting their contractors. The contractor cut into the fire system, and the fire lines ruptured, and there was a whole nother claim that came out of the whole thing. So it happens. It happens.
Yep. I've seen one very similar to that as well. I'm sure we've got stories to tell. We should do one of these webinars just with our stories to tell.
Yep.
All right, so then moving on, I just had this slide to really emphasize contracts. A lot of people, especially in the older days and smaller communities, that would do things, on a handshake. Well, I know John Smith down the road. I went to high school with his nephew, and he can do this writing, he can do this work, and let's put him to the job. That is not a good practice if you are a director of an association. You have a fiduciary obligation to that entire association. And if you are going to have a contractor performing work on the common elements, or if I'm going to get to in a minute, common area and a regular subdivision, you want to make sure that you're getting those agreements in writing. I do reference here AIA. They have a lot of form contracts that contractors use in construction, and this is a great resource. But even when you're using a form, they are very much, you'll want your attorney to review them and potentially make revisions that are specific to your project. Even if you do just use a form, or a contractor makes his own draft, have your legal counsel draft and review your contracts before you sign them. That is a really good practice. I hear a lot, we don't like to spend a lot of money on legal. And, my answer is you're going to spend a lot less on legal up front if you're getting counsel beforehand than you are on the tail end if something goes wrong. And then, we're trying to clean up the mess. It does cost a lot on the tail end. So if you've got to, increase your legal budget, your line item for the year for legal, you should have some funds to ensure that you can seek legal counsel to draft or review your already drafted contracts before you sign them. So then my next slide is to address reserves. And this is essentially your savings account, if you will. Most associations have provisions that require a minimum amount of reserves, say 10% of your annual budget, or they may have a dollar figure. If they don't, there isn't really any one statute that says all HOAs have to put money in reserves. Now, after the whole tragedy in Florida, I think a lot of state legislators are looking at going back to their statutes and revising to require reserves for an association so that, all of the owners can't say, well, hey, I'm not going to be here too long. I don't want to have to save because I'm not going to get the benefit of those assessments. Instead, making it uniform across everyone for a minimum reserve. South Carolina has not yet done anything like that, but I wouldn't be shocked if that is not forthcoming. But also, in addition to that comment, check your governing documents. Make sure that you're looking at specifically what the board is required to do. Typically, the board is tasked with setting the budget and assessments and assessing the owners and ensuring collection of those assessments. And if it says you need to have a 10% reserve, you need to comply with that, because if something happens and you don't have sufficient reserves or insurance to cover, you can bet that there's probably going to be an owner or a group of owners that's going to sue the board for breach of their fiduciary duty, and you don't want to be in that situation. Side note to that, always have D&O insurance. Just in case you do make a slip up, I have that insurance to protect you as a director. I understand it's a thankless job. Most associations don't compensate their directors. So there's always have that insurance to protect you in case you do make a misstep and you get in a legal battle over it. So going on, reserves can help paying large deductibles or covering repairs when an association is underinsured. That's just pretty common sense. And oftentimes, you know, if an association is hit with some disaster, sometimes the deductibles can be, you know, just outrageous. I know it's been a real struggle for a lot of associations here recently to obtain insurance, and just not only just obtain it, but something affordable. Insurance premiums have increased dramatically in the last couple of years. And so a lot of times, if you have that reserve fund and you have some event happen and you have to do significant repairs, you may be in the position of making the business judgment decision of dipping into your reserves rather than using the insurance proceeds, just because of the size of the deductible. So reserves are tremendously important. They're an important part of the whole planning and preparation for any type of catastrophic event or storm event. So here I kind of go into, you know, we're talking a lot about condos because I really do feel between the two, when you've just got the single detached neighborhoods, they don't have as many obligations and requirements and statutes to follow with regard to insurance provisions and repairs. So HOA insurance provisions on private homeowner property is extremely rare. I can't say I've never seen it, but it is very, very rare. And if it's not required in the governing documents, I certainly don't think the HOAs should be attempting to purchase insurance, to the extent they even can, insurance over privately owned homeowner property. However, they should be insuring their common areas. And so disaster planning and insurance as an integral part of that is generally only applicable to your common areas. And those are typically going to be the property that the association owns. I get a question sometimes, well, what if it's, you know, county maintained roads? I don't think that you don't have to insure county maintained roads, because if something did happen to those roads, I don't know, an earthquake opens up a crack, the county would be responsible with the maintenance and repair of that. Now, if it's privately owned roads, then absolutely, you own those roads, you're responsible for them. If something happens to them, you want to be able to either have reserve funds to make those repairs, or if insurance is applicable, to be able to dip into those insurance proceeds. Common area improvements absolutely should be insured, even if the governing documents don't say it, do it. That's common sense to me. If a director failed, or a board of directors failed to insure a clubhouse pool, something happened to it, nobody has enough money to fix it, you can bet there's going to be some lawsuits there. So that is absolutely a must, even if your declaration does not say you have to do it. Reconstruction, I would again refer you to your governing documents on how that's done and what votes are going to be required not to do it. But if the declaration is silent, I always recommend letting the membership vote. And the basis for that is that typically an HOA is made up of its members, and all those members have easement rights. I mean, although the association owns that clubhouse and has the right to create rules and regulations, it's closed at 9, you have to abide by our rules. Those owners do have an inherent easement right to use and enjoy those common elements. And so if the documents are silent and don't say anything about whether or not you have to rebuild, I'd say if I was on a board, I'd say let's just put it out to a vote of the membership. Let's let them decide. And that way we're protected, in that we're not making a unilateral decision that may later wind up in a lawsuit with an allegation that we took some action that we weren't entitled to take, or we made a bad decision with the use of the association funds. So moving on from that, that's really all I had here prepared for y'all today. I kind of expect a little more questions, but
two questions for you.
Yeah, great.
Trees are always a lovely topic in the association world. So if a tree falls from the common property onto a person's house or yard, who's responsible?
Well, that's going to depend. And we get that question a lot too. It depends on if there was negligence. So the typical gut reaction from everybody is going to be, well, it's on your property. But if there was nothing wrong with the tree and it just blew over in a storm event, then there really isn't any negligence on the part of the board of directors. It wasn't like they knew that the tree was dying, it was leaning over, everybody said it's going to fall. And that situation where they failed to act in light of knowing that this tree poses a safety hazard to property or person, then they could be potentially liable under a theory of negligence. However, having said that, insurance and liability are two slightly different things. And I do think a casualty like that would be something that the association should tender to their insurance carrier. And hopefully that insurance carrier would pay that damage. In the alternative, the homeowner's insurance carrier may also cover that damage as well. And so it's really not a bright line rule just because it's on someone's property. It's really, is there a claim? Was there any type of negligence? And if there wasn't any negligence, then the association really isn't liable under any tort theory.
Okay, so follow-up question to trees. If it's a neighbor-to-neighbor tree issue, does the association have any responsibility to help mitigate those issues between the two neighbors?
I would say generally no. However, if it's a situation in which one owner is violating the governing documents and the association has an inherent duty and sometimes an express duty to ensure compliance with the governing documents, then they may have to take a position of that tree somehow violates our governing documents. Maybe it's an eyesore, maybe it's they're not keeping their property in good repair and the tree's dead and it's about to fall over. The association could compel compliance with those provisions. However, if there is no violation of the governing documents and this is just a private dispute, then I would, that would be between those two owners, and the HOA wouldn't really have a claim against either one or want to get involved.
Okay. Another question dealing with fencing across maybe an easement or swale where water is supposed to flow. And in this case, it looks like water is backing up because of the fence into a neighbor's yard and potentially flooding the structure. Does the association have any responsibility to help resolve that fencing issue?
Again, it's going to really depend on the circumstances. So things that I would want to know are, is it on the common area? Is the fence on the common area? And if it is, and it's an owner's fence and they have an easement to have it there, that easement, if it's obstructing storm drainage, I think they would be exceeding their easement rights. Just because you have a right to put a fence across a portion of property doesn't mean you have the right to damage that property or impede a stormwater drainage system. And then in the alternative, if it is just an owner-to-owner dispute, there's no common area involved, there's no covenant violations. That to me sounds like more of a owner-to-owner dispute. And that happens all the time. You get folks arguing about things between their lots that really don't have anything to do with the HOA. It's not impacting common area. It's not impacting common storm drainage. And so that's kind of how I would handle the situation. You probably need more specifics in order to give an exact answer on that, that pattern.
I know my question, but we deal a lot occasionally with the difference between rising water and falling water. And I know rising water has been deemed more of a flooding type issue, and often communities don't have flood insurance. Any thoughts on communities providing flood insurance?
Yeah, I don't know. I'm really not too much in the know on flood insurance. My understanding is that, if you're not in a FEMA mapped flood zone, that it's nearly impossible to get flood insurance. If you are, it's absolutely possible and advisable. And if you have that insurance, it should be covering those types of flooding events. But y'all can maybe correct me if I'm wrong. Y'all are more out in the practice. I don't know that it's possible to get flood insurance if you're not in a flood zone, or at least maybe not through FEMA. But that's what I know.
Okay. So another question with trees. What if the tree falls over a creek? And I'm going to guess this tree is in common area, and is blocking the flow of the creek. Does the association have responsibility to remove that tree?
Oh, yeah, sure. Well, absolutely. So if their tree falls down, they may not have been negligent and caused the falling, but once it's fallen down, they do have to clean up their property that's fallen onto someone else's property or is damaging something else, blockage of a stream. Maybe it fell on someone else's property. They'd still have to clean that up. Absolutely.
Okay. Another question dealing with roofs and roof leaks in a storm. How long does an association have to tarp a roof when there is a storm coming and there's rain falling to not be deemed negligent in preventing or mitigating that damage?
There's not going to be a bright line time rule on that. I would say to consult with experts in that regard. There are absolutely a lot of businesses, companies that actually offer more of the engineering and logistical aspects of storm preparedness. I actually did a CAI seminar in Charleston recently, and there were companies that actually offer that service beforehand, where they go ahead and they measure everything. They know exactly how many tarps they're going to need if worst case all of the roofs come off of all of the buildings, and they have them stored locally so that whenever the storm hits, they're ready to go. If you take that type of action, there's absolutely no way that a board could be deemed negligent. You were totally prepared. You've hired professionals to prepare you in that regard. However, if you're not in that situation, the best advice I could do is say as soon as possible. You should be making every effort to get those tarps covering the buildings to ensure that you're mitigating further damage from the rainfall, water, whatever the case may be. And as so long as you are making all of those attempts, you're reducing the chances that you're going to get sued for some type of negligence claim or breach of fiduciary duty, understanding that some of that's going to be beyond your control. But my best advice would be to go consult with those professionals beforehand. Be ready beforehand. Don't wait until the storm hits.
And I'll mention that most contractors don't go out and get on top of a roof in the middle of a storm. So we're asked all the time.
But those storm preparedness companies, they do. That's exactly what they do. So yes, there are some, but I agree with you. Contractors are mostly going to say, I'll get to it whenever the sunshine comes back.
Right. But as long as you tried, right? That's okay. So who does an association contact to make sure that an HOA has all its property insured for the proper value?
So that's going to be, again, professionals. I said earlier, consult with your attorneys. I want to also go say, consult with your professionals. Number one, insurance brokers. There's a ton of great ones in North Carolina and South Carolina who do deal strictly with community associations. And they are going to be able to help you find the professionals that are going to assess what exact values you need in order to insure your property adequately. And there's also what we call reserve studies. I'm sure a lot of the directors have heard of these. those are also, there's professionals within those organizations that can also tell you, this is how much it's going to cost you to rebuild. This is how much you need to be putting back in reserves, because they even look to the future at potential anticipated inflation costs, labor costs, and they give you basically everything you need to, in order to set your assessments to ensure that you're putting away for reserves and also adequately insuring your common properties.
Yep, and I'll mention we did do a webinar maybe about 6 months ago with an insurance professional that talked about values and all the different things you need to be looking at. But there are some third-party companies that will help give you a better price for reconstruction and rebuilding to make sure that you are adequately insured. But that's an important topic because the rates are changing all the time. And you need to make sure that the building coverage is meeting the minimum threshold there.
Absolutely.
So I don't see any other questions. There is one comment about stormwater management can be called. So I know in North Carolina, there's some stormwater management, whether you're within the city or the county or the state, there are different stormwater provisions. So you can use stormwater when available to help mitigate that stormwater issue that we were talking about earlier. So and DENR, I think it's DENR in South Carolina, and maybe DHEC gets involved in North Carolina. So, but
well, and when we're talking about getting involved, I don't know if we're talking about like when storm drainage is blocked by a tree or covering roofs that have blown off, because I don't know any agency in South Carolina that will come help you cover your roof when it blows off.
No, I'm talking more stormwater related type issues.
Yeah, gotcha.
I was thinking with South Carolina, and I don't know, you comment on dams. I know South Carolina had horrible dam related issues. Those dams about 5 years ago.
Yep.
Anything to prepare for with a dam in storm coverage?
Yeah, well, I mean, that's just kind of part of your whole insurance. If you own a dam, you'll want that insured as well as the rest of your property. And again, those professionals that can go out and assess, this is the cost that it's going to take to rebuild this in a catastrophic event. And then you'll want to ensure that you get that insured. But to your point that with all of the dam failures that we had recently, or a little while ago, DHEC has gotten heavily involved in inspecting dams and sort of categorizing them based on their risk of hazard. And so we're getting a lot of DHEC letters to associations saying, hey, we inspected your dam, you need to do this, this, and this. I think it goes without saying you need to always comply with those demand letters from DHEC on maintenance and ensuring that your dams are in good condition so that they can withstand some of these big storm events.
Yep. And if you do not, if you do have a dam on your property and it has not been properly valued, or at least the replacement cost has not been looked at, have a professional look at those dams because they are horribly expensive.
Absolutely. Absolutely.
Yeah, I've had a dam in a community cost over $1 million, and it's just hard to think about it.
Sad. I mean, it almost can bankrupt an association.
Yes.
So.
Yes. So, well, that's it. Those are the last of the questions. Thank you to all that have participated today. Our next webinar will be next month on the third Thursday of the month. It will be all around banking. So getting into the investment, or at least the banking offerings from the different banks. So with CDARS and the ICS, and understanding some of the banking changes that have occurred recently. So hope you can join us then. Valerie, thank you again for your time tonight. And then I guess for all of your other board members that you'd like to share this information, it will be posted on camsmgt.com under the board member resources. So again, thank you and good night.
Thank you guys. Bye-bye.
Bye-bye.